Good morning and afternoon, everyone. Welcome to the third and final webinar in our 2025 estate litigation series, Beyond the Will, Managing Dependent Claims, Modern Family Dynamics, and Unexpected Heirs. My name is Vivian Ho, and I am an associate in the Trust, Wills, Estate, and Charities group at Fasken's Vancouver office, with a primary focus on estate and trust litigation. Before I introduce my co-presenters, please see the administrative information that are outlined on the screen. I would like to draw your attention to the survey and CPT certificate points. QR codes and links will be available at the end of the event to fill in our survey and to obtain your Ontario, Quebec, or BC CPT certificate. We would appreciate it if you could take a minute to fill out our survey as well. Joining me today on our Canada-wide panel is Yoni Feingold, Karen Wyke, and Joseph Stonehouse. Yoni is a partner at Fasken's Montreal office. He is part of the litigation and dispute resolution group. His practice is centered on the resolution of disputes concerning wills, trusts, estate, and general commercial matters. He is regularly called upon to represent clients, including heirs, liquidators, trustees, as well as local and international companies before the Superior Court and the Court of Appeal. Karen is a partner at Fasken's Calgary office. She is a seasoned litigator with over 20 years of experience. She practices complex commercial construction and contract litigation and arbitration, as well as estate litigation. Karen is recognized as a litigation star in commercial litigation in Alberta and one of Canada's top 100 women in litigation. Joseph is an associate in our Toronto office. He is a skilled litigator, passionate about resolving disputes. He has appeared before the Ontario Court of Appeal, Manitoba Court of Appeal, and Ontario Superior Court of Justice. He has also represented clients in domestic and international arbitration. Now, on to our presentation.
Great. Thanks, Vivian. As Vivian mentioned, my name is Karen Wyke, and I practice out of Alberta. I'm going to first give a sort of general introduction to the concept of dependence relief claims across Canada. Do keep in mind that it does vary quite a bit between the common law and civil law jurisdictions. And also there are some variances across the province. But I'm going to give that general sort of national overview, and we'll do a little bit of an examination on some Alberta case law. So just starting with sort of two overriding principles in estate law. One is that across Canada, in all jurisdictions, generally the courts uphold testamentary freedom. And that is the ability of a testator to dispose of their estate in any manner in which they see fit. The other overriding principle is that the last will and testament of a testator is paramount. We see this in all kinds of estate claims, how to interpret the will, whether other evidence can be admitted to interpret the will, that kind of thing. The courts see the will as the testator's last opportunity to speak, and they can no longer speak for themselves. And so disappointed beneficiaries and others are given very opportunity to influence how a will is interpreted. And the courts will always interpret a will from the perspective of what the testator intended. So those are the two general overriding principles, I would say. There are exceptions to both those. One is the exception that the testator doesn't have freedom to disinherit certain beneficiaries. And that the biggest exception, of course, are those that would be considered dependents. And so there may be unexpected heirs, people who a testator did not intend to inherit under their estate, who may make a claim to the courts and will be successful in varying the will. The most prevalent estate claims in the context of modern family dynamics are dependence relief claims, and dependence relief legislation across the country, which and varies provincially, allow dependents to claim against the estate of a deceased who failed to adequately provide support for them. The reason for that really is a policy underpinning because the government needs testators to take care of those who are dependent on them, and that those people will not access the public purse. Again, in modern family dynamics, at least the most prevalent claim I see are those of common law spouses, particularly where there's adult children. And the same legal issues tend to arise. One is, does the applicant qualify as a dependent? What is adequate provision, and are there bars to recovery? I'm going to spend most of our time today talking about the first two issues. Next slide. Yeah, so what is a dependence relief claim? I did set it out a little bit. It's a claim against an estate by a qualifying person, a dependent. That is a very loaded term, you'll see, for proper maintenance and support where the testator has failed to provide adequate provision. And where successful, the relief can include a lump sum payment, spousal support, temporary access to the marital home. Next slide, please. Tatterin and Tatterin Estate is a landmark case from the Supreme Court of Canada from 1994. It established that a will maker's duty is not only to meet its legal obligations, but also to provide for dependents in a way that reflects the modern moral and social standard. That case involved a farmer, I believe, a husband, who left very little for his wife of 43 years in preference of his adult sons. The court found that the will did not provide adequate, just, and equitable provision for the wife, and gave the wife and altered the will, essentially, the matrimonial home and the bulk of the estate, and the adult sons were left with $10,000 each. Some important principles were established in this case. Again, the moral obligation. The case was considering BC legislation, and so there is varying reliance on this case across the provinces, but it is sort of the starting point. What was thought to be adequate, just, and equitable in the 1920s may be quite different from the 90s and beyond. And the court determined that assessing adequate provision is determined at the date of death. Okay, next slide. The dependence relief claims in Alberta is set out in the Wills and Succession Act, Section 88. As I say, this is codified across the provinces in varying legislation. Again, it allows claims of a family member. And who qualifies as a family member in Alberta is also set out in legislation. In Alberta, the following number of dependents can make a claim: a spouse, an adult interdependent partner, a child under 18, a child over 18 who is unable to earn a livelihood due to a mental or physical disability, a child of the deceased between 18 and 22 who's a full-time student and living in the care of the testator, and also a grandchild under 18 where the testator was acting as a parent, what we refer to in the law as loco parentis. Next slide, please. Now, who qualifies as a dependent or as a family member in Alberta, as we call it, a family member under the Alberta legislation, actually varies quite a bit across the provinces. Spouses are generally on the list. Adult interdependent partners are on the list. Minor children are on the list and can, as we saw in Alberta, include grandchildren, adopted children, and potentially stepchildren. Not across all jurisdictions. And again, there's that test of loco parentis. Does the testator essentially assume the role of parent? Children over 18, as we mentioned, parents in some provinces, not in Alberta. brothers or sisters, again, in some provinces, not in Alberta. What about others, such as grown children? We're setting it up for the big disputes generally. Grown children, those children of the testator over 18 are generally not dependents. And if they are disinherited from their parents' estate, other than in BC, where there's some ability to challenge a will under the Wills Variation Act, there's very limited ability of an adult child who's been disinherited from their parent to make a successful claim against the estate. They would have to establish, at least in Alberta's case, an inability to earn a livelihood due to a disability. So next slide, please. Who qualifies as a spouse? This is a very interesting definition, and I'm sure it will continue to evolve in the law. We've seen some evolution. It generally means either of two persons who are married to each other or have entered into a marriage that is void or voidable, and also includes a common law spouse or adult interdependent partner. Across jurisdictions, and again, the requirements are slightly different, but where two persons live together for a period of time, that period of time can vary. They are considered and held at law to have the same rights and responsibilities as a spouse, as if legally married. For example, in Ontario, a spouse means a spouse as defined in their legislation, and in addition to two persons who are to being married, it can be two persons who are not married and have cohabited continuously for a period of not less than 3 years in a relationship with some permanence. And, the cohabit means living together in a conjugal relationship. Next slide. So who qualifies as an AIP, or adult interdependent partner? That's the Alberta phraseology, and that's actually set out in a separate piece of legislation, and comes up often not only in estate litigation, but of course also in family law, as spouses seek financial and other support from each other. So the partner must live with the other person in a relationship of interdependence for a continuous period of 3 years or more. That continuous element has become quite controversial. There can be periods of separation, and those periods of separation can start and stop the clock of the cohabitation requirement. There are other descriptions for where there is a child of the relationship where the two spouses are not married, or whether that child is by birth or adoption, or where the partners have entered into an adult interdependent partner agreement. Interestingly, in Alberta, including in the legislation, blood relatives can be found to be AIPs if they've entered into an adult interdependent partner agreement. Okay, so next slide. So there, not only do the persons have to cohabit, that relationship has to be a relationship of interdependence. And again, this is set out in legislation in Alberta. What does a relationship of interdependence means? It means where the persons share one another's lives, they are emotionally committed to one another, and they function as an economic and domestic unit. And so the court will consider all kinds of evidence to determine whether those requirements are met. The factors are also set out in legislation, some of which include that the relationship is conjugal and exclusive. They hold out as a unit. There is direct and indirect contribution to each other's mutual well-being. They do each other's laundry. They clean the house. They cook for each other. They drive each other to medical appointments. All of those considerations will be reviewed by a court in determining this kind of relationship. So moving on to the next slide, as you'll remember, one of the requirements of establishing the relationship is the cohabitation. And that in Alberta has to be a cohabitation for a continuous period of 3 years. It is a very complex situation. The Supreme Court of Canada has found that cohabitation is a constituent element of a common law relationship. And two people can be found to cohabit without living under the same roof. And conversely, as we know in the context of family law, two people who live under the same roof can be found not to cohabit. We see that a lot in divorces. There's a period of separation required before a divorce can be finalized, and often spouses will live under the same roof, but still be found to have lived separate and apart for the required period. So it has become a very complicated, I would say, area of the law. While I'm canvassing generally Alberta cases, there's an Ontario Court of Appeal case that is fairly recent, where the courts found that the parties had cohabited and met the requirement of cohabitation and continuous cohabitation, even though they did not live together. They lived in and reside in separate homes. They lived together in the summer at a cottage and vacationed together in Florida. And then they spent a significant amount of time together at their respective homes. And in that case, the court did find that even though they had not lived under the same roof, they had cohabited. And then the next slide, the Alberta law is replete with examples. These are just very few of them. Generally, we find them in the family law context where spouses or partners are claiming for support against one another. Where in each of these cases, the parties did not meet the strict 3-year cohabitation requirement, the first requirement for finding a common law relationship. And the court found that the partners had become adult interdependent partners within the meaning of the Act. In the first case, very Alberta case, the respondent was a pipeline foreman who was rarely at home, lived in hotels for most of the time, came back to Calgary for short periods, but while in Calgary, would stay in a hotel with his partner. Eventually, they purchased a trailer together with the intention of living in it together when he came back from the oil fields. And that intention in purchasing the trailer together and living in that trailer for short periods of time in a week was enough for the court to find that cohabitation. The next case was a relationship, young people, about 10 years, and the applicant, they were on and off. The applicant, they shared a residence in Sylvan Lake, but the applicant decided to take a degree at Calgary and was gone for most of the week. And those periods of separation were found not to interrupt the continuity of their shared living arrangement. The next case, Mitchell and Reichdale, very interesting, very modern family dynamic case. Similar kind of Alberta facts where the husband traveled up to the oil field most of the time. In that time, started a relationship, purchased many homes in which his new partner would reside while he was up in Grand Prairie, and his wife and 3 boys he kept in a separate city. They didn't know about each other. And in that case, and despite legislation which prevents somebody from having 2 partners at once, found that the new partner was also a partner of the respondent in that case. So lots of cases across jurisdictions that are finding cohabitation where the parties do not share a resident. Next paragraph. Sorry, next slide. So there has been, other cases. One of the leading cases have determined the opposite. One of the leading cases in Alberta, Henschel Estate, from 2008, has said that the prerequisites for finding an AIP relationship are independent prerequisites. And regardless of the nature of the relationship and how intertwined it is, the nature of that independence, the parties must meet the living together with the other person. And the living with the other person, the cohabitation continuous period for 3 years, you can't just be roommates. You do have to, that living together there has to be the interdependence. But in that case, the court found that cohabitation in the same residence is required, and the relationship of independence and how long it continues is irrelevant in determining the first requirement. And I think what we're seeing in some of the cases is that perhaps courts are emphasizing other requirements over the first kind of hurdle in establishing that relationship, being the hurdle of the living together for the continuous period. Next slide. So the further clarity has come more recently, just last year, in Alberta on the cohabitation requirement. The Abbott and Mamdani case, like the other cases, were decided in the family law context. And a very wealthy man had a claim against him of somebody he'd been in a relationship with for 4 years. She claimed they had become adult interdependent partners from the time of their first date. The court disagreed and sort of changed or helped with the test a little bit. The first question is, did the parties cohabit in the same residence for a continuous 3-year period? And if not, did they have a mutual intention to cohabit that was interrupted by external circumstances, which has really helped clarify the situation in Alberta. Next slide. Now that's the cohabitation requirement. As I mentioned, the court will examine all kinds of evidence to determine whether the parties are holding themselves out as a domestic unit. Tax returns are sometimes a very helpful and can be determinative in whether the parties hold themselves out. There's conflicting law on that as well. In some cases where the claimants identify themselves on their tax return as single, the courts will still find that they are married within the meaning of common law spouse. But other cases will find that where you make that declaration on a form, that is part of the evidence that if you're single, where you're not holding yourself out. So last slide is I'm just going to talk very briefly about what is adequate provision. The courts will assess, firstly, whether you're dependent, and then secondly, whether the testator has made adequate provision for the dependents. And while the legislation differs in determining the amount and duration, if any, of support, the court considers a number of circumstances as to whether the claimant has been adequately provided, which include their current and future assets and means, their capacity to contribute to their own support, their age, physical and mental health, their needs and a custom standard of living, the proximity and duration of their relationship with the deceased, any agreement between the deceased and the dependent, and the claims that any other person may have against the estate as a dependent. So those are some overriding principles and some interesting case law developments in Alberta. I'm now going to turn it over to my colleague Joseph to speak about some Ontario developments.
So in Ontario, the legislation sets out who is a spouse and therefore who could be a spouse for the purpose of dependent entitlement under Ontario law. As we've discussed, you don't have to tie the knot to be a spouse. So under the Succession Law Reform Act, the term spouse adopts the meaning from Section 29 of the Family Law Act, but also goes further. It includes two people who are married to each other, even if that marriage ended in divorce. So an ex-spouse can still qualify for support if they were dependent on the deceased prior to the time of death. The Family Law Act defines spouse as two people who are married to each other who entered into a marriage that was void or voidable, provided they acted in good faith. So this covers situations where the marriage ceremony was flawed, but the parties believed it was a valid marriage. And Section 29 expands the definition for support purposes. It includes two people who are not married but have cohabited. We've talked about that a lot already, but in Ontario, it's continuously for at least 3 years, or if they're in a relationship of some permanence where they're parents of a child. So in summary, for estate claims, the definition of spouse is broad. It covers married couples, divorced spouses, common law, and common law partners who meet these criteria. Now, we've been looking into who is a spouse to consider the impact on dependent claims against an estate. So let's look at a couple of examples. The first case is Bormans and Estate of Bormans. It's a 2016 decision. And this case highlights how Ontario courts apply the Succession Law Reform Act when a former spouse seeks support after the payer's death. And it also introduces an issue of what type of applicants can claim for what type of assets. Some assets form part of the estate, some of the deceased assets will form part of the estate, where other assets will go directly to a beneficiary. And what we learn is dependents can claim into those assets that fall outside of the estate. So in this case, Gabrielle was 63, and she's the former spouse of the deceased John Bormans. They were married for 38 years, and they divorced in 2010. The divorce order required that John pay spousal support, but he stopped paying in 2013, and he had about $4,000 or $5,000 in arrears. Now, as part of the divorce, John promised Gabrielle that she would remain the beneficiary of an insurance policy that amounted to about $175,000, and that was to secure support, including in case of death. But that policy was terminated in 2009. John died in 2014. He left his estate to his two adult daughters and named one of them Jessica as the estate trustee. So Jessica received $70,000 from that second insurance policy, and she spent most of it, even though she had received notice of Gabrielle's claim. Now, there are many factors to consider where someone's a dependent, and some of those include whether or not someone is able to provide for themselves. And Gabrielle was permanently disabled, she was unable to work, and she was living below the poverty line. And John's will didn't make any provision for her. So the court found that Gabrielle was a spouse under the legislation, and that's because John continued to owe her a legal obligation in the form of spousal support. And she was a dependent because of her financial hardship. So in this case, even though she was the former spouse, ex-spouse, she was still entitled to claim as a dependent. But the estate didn't actually have any assets, the estate itself. The only asset was these proceeds of insurance. And as I explained before, if the court finds that someone is a dependent, they can look to assets outside of the estate. So the court awarded Gabrielle money out of the insurance policy, even though those proceeds went directly to Jessica. Had Gabrielle just been suing as a creditor of the estate for the unpaid spousal support, she wouldn't have been entitled to go after the proceeds of the insurance. And Jessica was ordered to pay $40,000, even though there was nothing left from the proceeds of the insurance policy. So just to flag one thing, be careful naming children as trustees when creating a will, because if they mismanage the estate, they will be personally liable, and that's what happened here. Now, this next case had a more intricate examination of who is a dependent, and it's Miescu and Zodian. It's a 2009 decision. And I think this falls into what some people might think is an unexpected error. It involved a stepchild. And the court found that, yes, a stepchild can be a dependent where the deceased was looking after, caring for, supporting that child. And again, there's some interplay with marriage contracts in this case, where perhaps someone felt that they were safe because of a marriage contract. So Tatiana is the applicant, and she married the deceased Valeriu in 1995. Tatiana had a son, and the son Alexander, and Valeriu sponsored both Tatiana and Alexander's move to Canada. Now, on the day of their marriage, they signed a wedding contract, and it waived spousal support and proprietary claims on breakdown or death. And Tatiana also agreed to care for Alexander during the marriage and after separation, and not to claim against her husband for that obligation. But the court found that the marriage contract did not waive claims after Valeriu's death, and it did not preclude claims on Alexander's behalf. Now, to determine that Alexander was a dependent, the court considered the relationship between the deceased and his stepson. They found that the deceased sponsored Alexander on his move to Canada. He paid Alexander's expenses. He claimed it as a dependent on taxes. Again, taxes will be used as evidence. And they also had a relationship together. I find it a little funny, the examples that they use, because obviously based on what evidence was in court, but they talked about them reading together, swimming and biking. And the deceased also covered Alexander under his employer benefits. So for the court, this established a clear relationship of dependency. In terms of quantum for the dependency, Tatiana, the mother, paid for all of Alexander's expenses and litigated on behalf of her son for 6 years. The deceased's other adult son inherited the entire estate, and he was a bad faith litigant. He did everything he could, including just not responding to orders, and that certainly had an impact on this claim. But one of the worst litigants I've read about in a case, including completely ignoring court orders. Now, this was mentioned before. If an adult child is attending post-secondary education, those costs will be considered an independent claim. And Alexander had remained a full-time student after the death. So the court awarded both retroactive and future post-secondary fees in this case. And there were assets that fell outside of the estate. There was insurance proceeds, a pension, an RSP, and also the adult son obtained his title to the property as a joint tenant. So none of that actually passed to the estate, but it didn't matter. The court awarded Alexander $105,000 for past and future education and living expenses. And because the adult son acted as such a bad faith litigant, the court also appointed Tatiana, the mother, as the estate trustee. So the key takeaways from this case are marriage contracts can be limited, especially when children are involved. Going back to the Tattering case, the court will look at moral obligations. And the court narrowly construed the marriage contract. I also assume the fact that it was signed on the day of their marriage in a foreign country also played into the judge's decision, although it didn't expressly say so. I'm going to talk about adult children. particularly adult children that have been abandoned or estranged from their parents. In Justin Investors Group Financial, the deceased was the mother of Charlotte, and her husband had been separated since Charlotte was about 6 years old, but they never got divorced. Bonnie never paid her child support, and she had $14,000 in arrears at the time of her death. And again, this is another case where the only asset in the state fell outside of the state. It was a locked-in retirement account, and it was worth about $32,000. And the deceased named her adult children from another relationship, a previous relationship, as beneficiaries of that. Now, one important distinction in this case is that the father, Roy, applied as a parent, and he also brought the claim on Charlotte's behalf as a child. And the court said that's double dipping. If you're bringing the claim as a support parent, you're essentially bringing the claim on behalf of the child. And because the child also has a claim, they're going to throw out the parent's claim. And basically, the child support payments is what entitled Charlotte to being considered a dependent. At the time of death, the deceased was under legal obligations to make child support payments. Therefore, the child was considered a deceased. Now, this case is interesting from a quantum perspective because the courts will consider various sources of funding for the child. In this case, there are two parents. Both parents worked, although the mother made more than the father. So when calculating how much Charlotte was owed, they considered how much would her father have to pay, how much her mother would have to pay, and also how much money could Charlotte make over the summer working as a student. This one isn't too contentious because Charlotte was only 18 when her mother passed away, so it made sense, I think, that she was named as a dependent. But there's cases where much older adult children claim as dependents. And I'm going to quickly talk about two. One is the Louis and Latzman case from 2002. This was a famous case because Mr. Latzman was actually the mayor of Toronto at the time. And it didn't have to do with the estates, but it had to do with timing as to when adult children can claim from unpaid child support. And it turned out that Mr. Latzman had a secret family. And when they were in their 40s, they claimed against Mr. Latzman. But their mother had signed a release and basically signed away all rights and accepted a one lump sum payment. So the court said, no, the children aren't dependent. There was no spousal support here. And importantly, this went to the Ontario Court of Appeal, and they said, no, there's no need for a trial here. And this focus on no need for a trial is important because this year, there's a new case about us on Montréal. And in that case, the father left his 3-year-old daughter and her mother in 1991. The mother obtains child support order in 1998, and the father didn't provide full support. And in fact, he never provided financial support. Now, after his death, many years later, the daughter brought a dependent claim. And the administrator of the estate said, whoa, this is too long. You're 37 years old. You can't claim as an adult dependent. But the motion judge said, no, we need a trial to determine this. And they focused heavily on the moral obligations in this case and said the father had moral obligations to pay. He didn't make these payments. So even though the adult child stopped being a dependent in 2014 when she may have finished her secondary education, call her 22, 23 years old, and now she's 37 bringing the claim, the court said, no, we want to have a look at this. So I'm flagging this because there's potential that an estranged child can bring a claim at least until their 30s. And as of that, I'm going to pass it on to Yoni to talk about the issues in Quebec.
Hi, everybody. And thank you, Vivian, Karen, and Joseph, and thank you all who are joining us today. I'm going to cover the civil law portion of our presentation. And of course, one of the benefits of the civil law is that everything is codified in our wonderful statute, the Civil Code of Quebec. So join me as we do a deep dive into some of these articles that occasionally appear to be clear, otherwise are pretty opaque, but we'll get through this and hopefully you'll understand something about how dependent relief claims operate in Quebec. So the principal section of the Civil Code is found in Chapter 5, called The Survival of the Obligation to Provide Support, but we will reference other sections of the code as well. 684 is the general article, which says that every creditor of support, that is a defined term that we're going to spend a little bit more time looking at, may within 6 months after the death claim a financial contribution from the succession as support. So this right exists even where the creditor is an heir or a legatee by particular title. So just to put a flag there, it applies not just where the creditor of support has been disinherited, but as we saw in the other jurisdictions, where the creditor is in fact provided for under a will, but where there is inadequate provision of support for the creditor in question, where the right to support was not exercised before the date of death, and finally, it does not exist in favor of a person who is unworthy of inheriting from the deceased. So this refers to a different section under our succession book, which defines anyone who has treated the deceased in a reprehensible manner, who's concealed or destroyed a will, who has hindered the testator in making a will, or who's attempted to take the life of the deceased as being unworthy. So those people are naturally excluded from making a dependent relief claim. Okay, so the million-dollar question: who is a creditor of support? This refers us back to the section dealing with family law. So Article 585 of the Civil Code states that married or civil union spouses, and that is a category that we're going to look at more closely too. We'll get back to that in a moment. And relatives in the direct line in the first degree owe each other support. Relatives in the direct line in the first degree are both ascendants, so parents, and descendants. Of course, I suspect my colleagues would agree, we very rarely see any claims of support made by ascendants or parents, and most of the cases that we come across deal with descendant claims. And of course, this also does not cover siblings, so they're expressly, or they don't appear to be included. So back to the first category of married or civil union spouses, you may find that reads in a very limited way. And if you've read it that way, you are correct. So who's excluded from that category of creditors? Well, the first group are the de facto spouses. No de facto spouses, or as the common law jurisdictions refer to them, common law spouses. And this is totally in line with the decision Eric v. Lola several years back, where the Supreme Court essentially upheld and confirmed the status in Quebec, which was that if you want to have the rights and obligations of marriage, you get married or civilly united. If you want to opt out, all you have to do simply is opt out and not get married, and you're not governed or bound by any of those onerous or wonderful, depending on how you look at it, obligations and rights that protect the partners or the spouses. The other excluded group are parental union spouses. Now, this is something that is very new to Quebec. It only came into effect in June 2025, so just a few months ago. And it's also part of the legacy of Eric Vilola. The Supreme Court said, look, it's up to the legislature to decide to afford more protection to certain types of couples, and left it in their court. And after a number of years and much deliberation and debate, our government, in its wisdom, decided to create a regime essentially to protect families with children, and to maintain the stability for those children in the event of the dissolution or breakup of that family unit. So it created what we know now as the Parental Union Spouses Regime, and I'll read to you Article 521.20, which defines a parental union as follows. A parental union is formed upon de facto spouses becoming the father and mother or the parents of the same child. The same applies where the father and mother or the parents of the same child become de facto spouses or become de facto spouses again. So again, what is central to the notion of parental union spouses is the parent portion of it. You're parents to a child. You benefit from sort of a cascade of rights and obligations upon the dissolution throughout the union, upon the dissolution of the union, whether it be through a breakup or, in the case that we're going to discuss and look at, death. And those rights principally concern the distribution or access to assets and property and succession rights. We're going to disregard anything to do with the family patrimony and property and just look at successions for now. What the code has now provided is that in the case of an intestacy, and I'll read to you Article 653, unless otherwise provided by testamentary provisions, so we're in an intestacy, a succession devolves to the surviving married, civil union, or parental union spouse and the relatives of the deceased. So the court, or the legislature, has decided to include this notion of parental union spouse along with married spouses and civilly united spouses in the context of intestacies. So, but does not afford them any rights or benefits as creditors of support in the event of death. So essentially, if you are a parental union spouse, you have more protection upon the death of your spouse than upon the breakup. And this is one of the key inconsistencies that has been brought up as a critique of the regime, which is essentially considered to be a half measure and has not gone far enough to protect vulnerable spouses and protect the children who are the issue of such unions. And particularly confusing given the fact that the regime permits parents to opt out, to expressly opt out of the parental union if they don't want it to apply. So why not give them all of the rights? Not clear. I don't have an answer for you. We'll see how that evolves and whether there'll be challenges down the road. All right, determination and payment of support. So how is this payment made? Much like the other jurisdictions, it's either in a lump sum or by installments. And in the second paragraph, we see it is fixed with the concurrence of the liquidator of the succession, acting with the consent of the heirs and legatees, or failing agreement by the court. Okay, so Article 686 of the code determines the amount of the support, or how we are to determine the amount of the support. And it really provides for an equitable approach and the balancing of the interests of all of the parties and all of the parties that are interested in the succession as a whole. And that equitable approach is really reflected in the language used in this article. So you'll see in fixing the contribution, it says the needs and means of the creditor of support, his circumstances and the time he needs to acquire sufficient autonomy, or if he was in fact receiving support from the deceased at the time of death, the amount of the installments that had been fixed by the court for the payment of the support or the lump sum awarded as support are taken into account. So needs and means and circumstances, it's all very fluid and it's all very discretionary. And the court is going to look at that in light of the following. Account is also taken of the assets of the succession. So is this, are there a lot of assets to go around? The benefits derived from the succession by the creditor of the support. So is this creditor, we saw the descendant, the spouse, are they already receiving something and benefiting from the estate? If so, how much? The needs and means of the heirs and legatees who are not creditors of support, so the other heirs of the estate, what are their needs? And where that is the case, the right to support which may be claimed by other persons. So as you can see, it's a holistic approach in determining how much is going to be awarded when a dependent relief claim is made. Okay, so Article 688. This addresses the limits on the amount of support that can actually be paid out. And it says, the contribution granted to the spouse or to a descendant may not exceed the difference between 1/2 of the share he could have claimed had the entire succession, including the value of the liberalities, devolved according to law, and what he receives from the succession. Not clear. You may have to read this about 25 times, but it's a complicated way of saying that the payment that a creditor of support can receive is limited and cannot exceed half of what they would have received in an intestacy. And just to clarify that, so we have rules on the order of devolution or legal devolution in the event of an intestacy. Classic case, there's a surviving spouse and children. The code provides that the spouse will receive 1/3 of the estate. The children will receive the other 2/3. They'll split the other 2/3. So this Article 688 says that you cannot, neither the surviving spouse nor those children in that case can receive more than half of what they would have received. So half of the spouse's 1/3, half of the children's 2/3. And of course, you take into account what they already receive under the will, and then you figure out the difference between the two. The second paragraph deals with former spouses who are already receiving support. So it's limited to 12 months, but it's really the lesser of 12 months or 10% of the value of the succession. And in this second paragraph, they also deal with the other creditors, so the ascendants, and there's a lesser period at 6 months, and again, cannot exceed 10% of the value. Okay, I'm just checking the time. Okay, we have a little bit of time. I'm going to work through a very interesting case that was rendered very recently in April 2025, called VM versus Directeur de l'État Civil. It was a 105-page decision. We're going to make our way through this. Let's look at the key facts. So several families formed through assisted reproduction and joint parental projects sought legal recognition of more than 2 parents for a child, what we call multi-parental filiation. Quebec Civil Code restricts filiation to 2 parents only. The plaintiffs argued that this violates the equality rights under Section 1510 of the Canadian Charter and Section 10 of the Quebec Charter. They also raised challenges under other sections, which the court did not uphold. So really focused on Section 15, which is discrimination and equality. The main petitioners were 3 sets of families that we'll look at, as well as interveners, which included advocacy groups, the Coalition des Familles LGBT+, and Égal Canada. Basically, this case addresses the fact that the law does not reflect the reality and the diversity of modern family structures. And the court reacted and responded accordingly. So let's look at the 3 family units. The slide has a small error. Just the initials of family 1 and 2 should be inverted, and I'll describe the three cases that were brought. Family 1 is a lesbian couple that desired to each have a child. They wanted their children to be genetically related, and they wanted the father, who was to provide the genetic material, to be actively present in the life of their children. So they wanted the children to be biological siblings with a father in place. They found their unicorn and pursued their project. There was only one successful pregnancy that resulted, but all 3 wanted to be officially recognized as parents on the birth certificate. In Quebec, only 2 can be recognized or identified. The second family unit was a heterosexual married couple with 3 children. The husband and wife served in the military. While the wife was overseas, she fell in love with a woman. Her husband accepted to pursue a polyamorous relationship, so it was the husband and the wife with her girlfriend. And the woman who joined, so the girlfriend who joined, wanted to have a child of her own. And all agreed that the best way to proceed was to have the husband provide the genetic material for the baby. The court found that the 3 children from the marriage viewed this as totally acceptable and harmonious within their family structure. And they had that child, and they wanted all 3 to appear as parents on the birth certificate. The third family unit, there's Madame L and Madame A, who are very close friends. Madame L and Monsieur are de facto spouses living together for many years. Unfortunately, Madame L is diagnosed with leukemia and decides before her treatment to produce and freeze embryos with the genetic material of her partner. Madame A, who, as I mentioned, is a very close friend of Madame L, she wants to have children of her own. She had been recently divorced, and they start discussing, the 3 of them, very seriously embarking on this joint family venture where they were all 3 to participate in a family project. So Madame A, who's the friend, then has a baby with the genetic material of Monsieur, but only the 2 girlfriends, Madame A and Madame L, appear on the act of birth, and the father, who's genetically related to the child, does not. Later, Madame L, who had the embryos frozen, and Monsieur engage a surrogate to carry an embryo, and they bring to term a child who they adopt. And there are now 2 children issued from this family project, and they seize the court wanting to have their family unit recognized as an equal and just as legitimate family unit. So the main issues that were decided by the court is, does the 2-parent limit in the Civil Code violate the constitutional equality rights? The answer is yes. The restriction is discriminatory and unconstitutional, and recognizes family status as an analogous ground under 15.1 of the Charter. And the outcome is that over 40 Civil Code articles are struck. That is suspended, however, for a period of 12 months to allow for legislative amendments. But of course, everything is now in appeal, so we'll see how this unfolds, but it's certainly going to be fascinating. Just very quickly to bring it back to the topic in hand. So what impact will this have on estate law and dependent relief claims? Of course, this is brand new, so we don't know, but some of the questions we might ask are, will a child be able to make a dependent relief claim from 3 estates? And that child obviously has different rights than a child who only has 2 two parents? Is there some distinction that can be validly made there or not? And of course, given that it's an equitable remedy or relief, I'm confident that the court is going to take that into account whenever assessing that. Similarly, will the estate of a child or a descendant who passes away have three ascendant dependents? Are there suddenly going to be three parents who can make a claim against that estate? And another last question that we could ask is, will the parental union be extended to three parents? And again, we should not expect that marriage will be extended to three spouses, but given that the parental union was a regime that was put into place and enacted to protect children and maintain stability, how are the courts going to deal with this? How's the legislature going to deal with this once a final decision is rendered in this case? So that's what I have to contribute from Quebec. Thank you.
Thank you, Yoni. Maybe we could just sort of wrap it up here. Just one more slide. There's such a variance, isn't there, across the provinces and this between the civil and common law jurisdiction, right down to who can claim. I think the other thing that's very apparent is the evolving nature of the family unit, and who gets to claim. So the question, I think, then from a state perspective is, can a testator protect themselves from these kind of claims? Can they uphold the sanctity of their will? Lots of testators try through what's known as an inter rerum clause. An inter rerum clause is generally those kind of clauses contained in a will that says, if you challenge my estate, you will be disinherited. Those kind of clauses, there's lots of case law. We could do a whole presentation on just inter rerum clauses. Often they're found to be unenforceable, again, for public policy reasons. There are ways to draft them, but you have to not disinherit intended beneficiaries. The importance of prenuptial and cohabitation agreements are important. As we saw, particularly in the common law jurisdiction, in the cases of common law spouses, there are lots of claims of those spouses. And unlike in a relationship that's ongoing and where parties are making claims that they are common law spouses and both parties are there to testify about what their intention is, in the case of an estate claim, that is not the case. So you just have a wannabe beneficiary claiming that there was a mutual intention to hold themselves out as a domestic unit. It's why it's important to enter into agreements. As we saw, it's important in the Ontario case law, it's important to be very comprehensive about those agreements and how they extend to even to a dissolution of the estate. So the big guard against these kind of claims and the biggest takeaway is to properly provide, to think of dependents and to properly provide for them adequately in the will. Otherwise, you're opening your will to a challenge. And that would, I think, be the biggest takeaway. Vivian, I'm not sure if we have time for one or two questions. I note that we've gone over time.
Yeah, I'll try. A big thank you to Karen, Joseph, and Yoni for their presentation. I personally found the case law from the other provinces and the development quite fascinating. We only have a minute or two for me to tackle some of the questions, so I'm gonna give it a shot. The first question is, are there any special considerations to be mindful of in the context of adopted children or when the public guardian is involved? We've heard from our presenters that the definition of a dependent varies across provinces. In BC, a child must either be the biological or adopted child of the deceased to qualify to bring an action under the BC legislation. Stepchildren or a birth child who has been adopted by another party outside of the marriage do not have standing to apply for wills variation. And when a minor is involved, for example, when a minor is a wills variation claimant, the public guardian and trustee and the court will need to be involved to ensure that the minor child's interests are protected. Unlike other types of litigation, the guardian of the minor child may be conflicted out of acting for the minor child. So cases involving minors are almost always overseen by the public guardian and trustee and the court. I see that I don't have another minute for another question, but thank you everyone for joining us today. You will see information on your screen for CPT credits for Ontario, Quebec, and British Columbia. Links have also been added to the audience chat. If you don't get a chance to claim your certificate today, they will be sent next week as well. If you've missed the first and second webinars in the 2025 estate litigation series, the recordings are available on faskens.com. Thank you again for coming, and I hope you enjoy the rest of your day.